You all to this new session of our AI-TPT series, AI Tech and Policy Talks after the summer break. I see that people are still joining, but we wanted to start now also because we have one participant and our commentator, distinguished commentator, Tatsuro Ueno, who is in Japan, where it's getting pretty late. So we certainly don't want to keep him on hold too long. So for those of you who are not familiar with our AI-TPT series, this is a series of webinars that we have launched at the Digital Law Center that basically has the mission to offer a forum for discussing cutting-edge AI tech and policy issues and for fostering an interdisciplinary discussion about these issues. And today we have the great pleasure to welcome as our keynote speaker, so to say, for this session, Professor Thomas Margoni, who is research professor of intellectual property law at the Center for IT and IP Law, CTIP of the Faculty of Law of the University of Leuven, KUL. And Thomas Margoni will present today his recent work on the topic property rights approaches in the regulation of AI in the European Union. And he will do so by discussing an article that he has written together with Martin Kretschmer that they recently published in the very prestigious journal, GRU International Legal Journal, on the two exceptions for text and data mining, the TDM exceptions, as we know and we call them, that have been introduced in the European Directive on Copyright in the Digital Single Market. I'll be sharing the link to the article in a few seconds on the chat. And as those of you who are familiar with our system in the AI-TPT series, we will have, after the presentation of our speaker today, Professor Thomas Margoni, will have commentators, two commentators who will basically express their views and make comments on the presentations. And today we have the pleasure to welcome, and actually to welcome back, Anna Andrievich, who used to work with us at the Digital Law Center. Welcome back, Anna, and now is in Munich working on her PhD project on the topic of copyright and AI. And our second distinguished commentator, to whom I've already referred earlier, is Professor Tatsuro Ueno, who is kind enough to join us in the middle of the night from Japan, who is a professor of IP law at the University of Waseda, where he is also the deputy director of the Research Center for the Legal System of Intellectual Property at Waseda University, or CLIP Center, and also a very distinguished expert in copyright law, as we know and as we will hear later on. And after our two commentators, we will, as usual, open up the floor for discussion with our speaker as well as with our commentators. So do feel free to join in and make comments either by raising your hands or also by using the chat function that I'm sure you're familiar with. Please note, as you can see on your screen, that the session is recorded and will be made available online on the website of our Digital Law Center, so that people who could not attend today will have the opportunity to watch the session later. Before giving the floor to our speaker, I wanted to take a group picture. For those of you who can turn the camera on, that would be the moment to do so. And I would kindly invite Amjad Joseph, with whom we organize this AITP series, to take the group picture, which is also the opportunity for me to thank Amjad for all his help in organizing this AITPT session.
Thank you very much, Professor. So on the count of 3, I will be taking a group picture. 1, 2, 3, smile. Perfect. Thank you very much.
Wonderful. Now we've done the social part, or part of the social part, we can turn to more serious stuff. And I turn the mic and the screen and the virtual floor to Thomas Margoni for his presentation. Thanks very much.
Thank you very much, Jacques. I hope I have muted myself successfully. Well, first of all, thank you for the invitation to this great venue. It's really a pleasure to be here presenting some of my research together with you. I really look forward to the discussion with the distinguished commentators. Thank you both to Tatsuhiro and Anna for your time and for your comments. So for this purpose, for our discussion today, as Jacques has mentioned, I will mainly be looking at a recent paper that I have written together with Martin Kretschmer, who sends his regards and who has wished to be here with us today, but he is teaching right now, so he is not. At least he told me he's teaching. But I think it's useful for our overall understanding of the analysis that we are developing in the paper to give you a very brief but a bit more background on what we have done and how this paper came to light. So this paper and a second paper that I will also be referencing are basically the finally deliverables of a project called Recreating Europe that is funded within the Horizon 2020 European Framework Program. The project is, as customary for these projects, lasts for a total of 3 years, and which will happen at the end of December. So we have a couple of months left, meaning that the project has almost completed. Is a broad project. We have different components and tasks. Ours focus specifically on the aspect of training data in AI applications, or better within AI on those applications that rely on big data or massive amounts of data in order to extract information and so develop certain conclusions. We focus on these AI applications. For brevity, we refer to them to AI, but we clarify the fact that not all AI relies on machine learning and data-intensive technologies. We do that from a corporate perspective, or at least at this point, at the end of the project, I should clarify that that's how we started. But you will see my conclusions that we have also noticed different parallel, newer, concurrent phenomena. We have a dedicated web resource. I posted here the link on the slide, knowing that the slides will be circulated. So I have also a couple of screenshots later on, but I think this could be a useful resource for you in case you want to know more. And within the broader project, the team that has worked on this specific task is, you see them there, it's been our route until 2021, Martin Kretschmer and myself. There are two main legs or conclusions which are taking the shape of two separate papers that I will refer here today. They're very much connected. So the first paper, it's more or less the methodological foundation of the work we have done. It's called AI, Machine Learning, and New Corporate Law, Social Linear Analysis of Ownership Issues in Training Data in the Context of 3 Case Studies. Very long but descriptive title. And as I said, this lays more or less the foundations in terms of technological analysis for our subsequent work, which is the legal analysis more properly conceived, as it's more common and familiar to us as lawyers. We have identified 3 main cases: data scraping, natural language processing, and computer visions. If you're interested, we can discuss it later, but we explain how they have been selected, on which basis, and how they have been built. But our main motivation to proceed in this sense was to somehow, go back in time 3 years, because that's when we started, and even a little bit more, because that's when we were writing the project that eventually has been funded. Text and data mining was a rather debated topic. One of the dangers would have been that of having our analysis somehow influenced by the kind of public discourse that was shaping the representation of text and data mining in that specific moment. This kind of representations might have been influenced in different ways by policy, professional, business, trades, various lobbying groups that could have impacted the way in which we could have conducted our analysis. So on the basis of that, we thought that a good starting point would be, instead of starting from the law, starting from the technology, relying and hoping that perhaps this approach, more than a legal one, would have allowed us to delineate a factual scenario as possible, as close as possible to the reality of technology as we could. And we use this analysis and this information as basically the factual findings that we have used then to develop our legal analysis. Here, as I said, these are the screenshots of the first part of the page that I've linked. The goal is not to enter into the detail, but just to give you a sense of the kind of methodological analysis that we have adopted in order to develop our subsequent legal analysis. And the way in which we have tried to both build and validate the factual determinations that we have used, as I said, through case studies built in consultation with stakeholders, so mainly technologists, both from the public and the private sector, and then further validated through expert workshops. And here you can see an example of one workshop that we held in Glasgow in 2021. From this first leg of the work, we, as I said, developed our more proper legal kind of insight and analysis into what would be the legal implications of the technological development situations, problems, concerns that we have identified. I could summarize some of our most meaningful findings as follows. So especially for the legal analysis focused on the text and data mining exceptions. So we started, as I said, with a strong attention to the copyright environment. To us, this meant throughout our analysis, the centrality of the right of reproduction, in the sense that, especially within EU copyright law, the right of reproduction is defined very broadly in a way that has the potential to capture most of the activities that within the digital environment we would call use, but from a very specific point of view, that of Article 2 are in fact a reproduction. So the role of Article 2 of the Information Society Directive, it's a first element that stands out, possibly also from a comparative perspective. Something that certainly stands out from a comparative perspective is the presence in the EU of the sui generis database right. That is to say, of the related or a neighboring right, depending on national classifications, but certainly so special to have deserved a name sui generis that effectively extends protection to certain amounts of data. So I will not discuss it in here. I'm sure that we all know more or less how it works, and if not, we can expand during the discussion. But the sui generis database right, just for the sake of clarity, is a right that protects substantial amounts of data that has been collected in a qualifying database through a substantial investment in the obtaining, verifying, or presentation, but not creation of data, against acts of extraction or reuse. So it's a rather complex, long definition, but essentially it means that there is an element of copyright, or better, related right, that effectively protects amounts of data in absence of any originality, just for the investment present in those, reflected in those data. And this is almost a uniquely EU solution. And then the usual features of EU corporate law that we know, meaning limited exceptions. So those contained within Article 5 of the Information Society Directive, plus some additional ones in the Database and Software Directive, and the new ones contained in the Copyright in the Digital Single Market. And here are particularly relevant Article 3 and 4 on text and data mining. So our first conclusion would be that EU has a low threshold to enjoy protection, especially if we compare it with extra EU legal systems, and a high threshold to benefit from exemptions. We also observed a quite not new, but still quite meaningful tension in new corporate law between what is EU law and the needs of EU law and those of copyright law. We discussed this to a certain extent in the paper, but not necessarily the goals of EU law correspond exactly with the goals of a copyright system. So because the area of law that we are discussing is EU copyright law, this creates some sort of internal tensions between these two elements of the field of law that we are analyzing, that in several situations leads to inefficiencies. And again, I'm happy to clarify this further. Going on, then, trying to systematize these findings, we have coined the term a property-based approach to the regulation of data, and therefore of the technologies that relies on the use of data, which is quite distinctive of the EU approach. So in other words, we could say that in the European Union, artificial intelligence development largely relies on 2.5 corporate exceptions. I say 0.5 because we have the mandatory exception for temporary uses of Article 5.1, which is useful, but it was drafted with something very different in mind more than 20 years ago. So while it is still useful and the Court of Justice recognized this usefulness, especially in the FAPL case, it doesn't offer that kind of a comprehensive framework that we need for AI. And here I have a couple of questions that we ask in the paper in terms of what does it mean in terms of regulatory competition. To give you an example, the UK very recently has published a study where they suggest to repeal that part of the text and data mining exception that limits UK TDMs to non-commercial uses. And that's because through Brexit, they're not bound anymore by Article 5.2a of the InfoSoc directive. So that's a possibility that is real, and it is contemplated. And one of the reasons is precisely that of creating a more attractive and competitive legal framework for high-tech companies. So what does this mean for Europe? And I also have the same question, of course, for the US, because we know they are not the only one, but they have a very broad fair use standard. and the Supreme Court of the US has already confirmed that at least in a certain number of cases, mining the web is a transformative activities and therefore covered. And also for Japan, I know that we have Tatsuhiro with us today, so I leave this for him. But Japan has a much more generous exception in this area. So we ask ourselves, what does it mean? Will EU AI be developed in other countries because there is a more competitive economic or regulatory framework? And finally, in our paper, we conclude identifying a new approach that can be put in parallel and perhaps in divergent terms with the property-based approach that we call a governance-based approach, that is of more recent development, is based on a number of acts that now are only expressed through acronyms. The Data Governance Act, Data Act, AI Act, DSA, DMA, PSI, so Public Sector Information, Open Data Directive, Free Flow of Non-Personal Data Regulation, etc. More than half of which are still are still proposals. But they all somehow are part of a common and convergent approach to the regulation of data that is not based on the traditional property law concepts, but are more tend to look more in the direction of access rights, portability rights, and reusability. So we have seen these two approaches. Of course, due to the nature of our work, we have spent most of our analysis focusing on the first one, because that's what we set out to study in our project. But you know, halfway or 3/4 through the project, once we have seen and conceptualized this property law approach, we also have noticed that it was not just one new legal intervention, let's say the Public Sector Information Directive that has been around for more than 10 years, albeit subsequently reformed and updated, but there is a whole almost coherent approach that is part of the EU policy for the digital economy, and all these acts somehow create a rather consistent framework, consistent at least if we assess it internally, but we are worried that it will not be consistent if we compare it with this more property right approach. So here it's our, I would say, first conclusion represented graphically. So this, in our words, is what the property-based approach to AI, so to text and data mining, but this means to AI in the EU will look like. I don't plan to go into the details too much. As you can see, it was designed by a lawyer, not by an artist or someone gifted with any graphical ability. That was, of course, self-reference. But I think that it's important here to note something. The number of decisions, think of those decisions as the boxes in blue. Every time that you have to make a decision, this decision is a legal assessment kind of decision. On the rather complex issues, this can be it can be called costs. So every time we have to make this decision, every time that a startup, every time that an SME, every time that even large companies have to decide whether they can text and data mine, which, because of what I said before, means in the European Union whether they can train their algorithms on data that they don't own, this is a cost for them. Obviously, cost impact differently companies, firms of different sizes. So we have a first potential issue here, a strong incentive or a strong disincentive for smaller companies to follow the rules of EU copyright law. And if they don't do that, what do? Either they move to a different sector. So instead of developing AI, they develop different type of software, not based on data analytics. Or if they have the possibility to do so, they do that in a different legal system, perhaps in a legal system that is cheaper. Think of the UK if they pass this reform for the text and data mining exception, or think of the US. If you're a large company, if you're Google, probably you can easily decide where you want to train your models, and then you only circulate the trained model. At that point, it's going to be very difficult to determine whether that has been done infringing any copyright. Plus, you introduce all the issues of private international law that we know have a cost in itself. Or perhaps if you stay in the EU, you simply decide to train anyway and don't tell, because it's very difficult to go back to reverse engineer a trained model and identify what was the original training data. But then in this case, you're introducing a quite strong incentive towards obscurity, opacity in the AI applications that you're developing, because by declaring which have been your training material and allow therefore accountability, transparency of the AI application, you run the risk of denouncing yourself as a copyright infringer because you didn't clear the rights in the first place. And all this, it's because of copyright rules. So here I think we have a quite good example of how rules that are not intended to be the sole judge of how and whether and in which direction technology in general and artificial intelligence in particular should behave, play a role that probably they didn't want to. If we could think of copyright as a person, I have my serious doubt that copyright would be happy that they have to regulate this field of our reality, because that's not what they have done throughout the history of this of copyright law. This is not the kind of regulatory environment for which they have the tools to, and they have to cope with what I called a competing model that seems to have better tools to regulate copyright in this field. The sound that you have heard is my own time, so I know that I'm running out. I will conclude very quickly, have just 2 slides, but the first one summarizes in words more or less what I have just said. Perhaps the only thing I want to say in terms of the implications that more expensive against a cheaper training environment may lead to is the example of Article 17, since it is a quite concrete example that we can all relate to. So Article 17, of the Cooperate in the Digital Single Market Directive, we know that creates a situation of almost mandatory filtering obligations. We know that there are a couple of steps that can be done before best effort to obtain a license, etc., etc. But most likely we will end up in a situation where CCSP will have to filter content. But they also have to ensure that the fundamental rights of users, especially criticism, review, parody, so those that are underpinned by fundamental rights, be safeguarded. How do you do that? Because if you want to block infringing copyright videos, you can use matching and fingerprinting technology. You don't need AI. But to determine if a certain use is parody, we all know that the problem is this one. Judges have a difficult time to do that. Technology is not there yet. But if there is a chance for technology to best guess what is parody, to determine a contextual meaning, is through AI. And in this case, what does it mean? Because in EU, we cannot train models unless you are Google. So may it mean that we are somehow importing a foreign concept of parody into the EU through filtering obligations? Because, to train our models in the US is a lot cheaper. So probably market operators will have an incentive to train their models in a cheaper legal system. But if we train it in the US, does that mean that that model is trained on a data set that embeds the cultural and values of the US system, so that somehow embeds the concept of parody as applied in the US social legal system? And then we import it into the EU. So we will determine in the EU what is parody on the basis of values that are aliens to the EU, just because corporate law was designed in this way almost by accident. So this is something that we also discuss not in this paper, but I have linked it in the last slide. But I thought that this was something interesting to point out. And finally, but very, very quickly, because I will also have more or less mentioned this already, this is the governance-based approach that is an expression of the legislation that I mentioned, the DA, Data Act, the DGA, etc., that are not based on this traditional concept of property, of exclusion, of licensing, but it's based on elements such as access, control, reusability, and portability, in some sort of effect that, I am a corporate scholar, but when I talk about this with my colleagues from personal data, they tell me, oh yeah, this is GDPR all over again. So there is some sort of GDPRization of non-personal data in this field. So are we regulating non-personal data flows through governance models that are not based on proprietary approaches, but more public law approaches? That's something that, honestly, if you ask me, it's probably happening, but is not exclusively happening, in the sense that in the intention and in the policies of the European Union, we will end up with a mixed system called data spaces, where public law, traditional public law approaches, and private law approaches are somehow mixed and combined together in order to obtain the ultimate goal of the EU, which is to extract value from the data that is held by public sector bodies, but that's easy done. The difficult part is those held by the private sector bodies. And this, I think, it's the big challenge for the next few years that we will be witnessing. Thank you very much.
Thanks very much, Thomas, for this fascinating presentation. A lot of food for thought and certainly topics for discussion. But in the interest of time, I would suggest that we shall now turn to Tatsuhiro Ueno, who will share with us his thoughts, and he will do so on the basis of a PowerPoint presentation for his comments. Tatsuhiro, you have the floor.
Thank you very much for a kind introduction, Jack. It's a great pleasure to be able to virtually take part in this event and to make a comment on the excellent presentation. Let me share my screen just for showing. So my name is Tatsuhiro Ueno from Waseda University in Tokyo. Professor Thomas Margoni and I have met several times, but the first time was 6 years ago. We were both invited by the Korean government to the Seoul Copyright Forum. As you can see, Professor David Nimmo was also there. And at that time, Thomas gave presentation on the liability exemption of data mining for the purpose of big data analysis. And I gave a talk on artificial intelligence and its creation. So that means we have been interested in the similar topic. So I'm very happy to see you again online today. So first of all, I would say it was excellent presentation. I'd like to extend my congratulations to Thomas. I'm not sure whether I understand correctly your presentation and your article, but let me talk about 2 points that struck me. The first point is about the TDM, text and data mining copyright exception, and the CDSM directive, and the implication or the effect on the practice of AI visions or the development of AI business or developers. So Thomas examined the text and data mining copyright exception in the CDSM directive, and in my eyes, he criticized the existing provisions, and he pointed out that due to a limited scope of the TDM exception in the EU, as a result, EU-based the AI developers have to train outside the EU and use trained AI in EU or import pre-trained model. And as a result, the narrow exception leads to the exact opposite effect. So it's quite interesting observation. So as Thomas examined in detail in his article, the text and data mining copyright exception under the CDSM directive is limited in some points. So let me show my screen. If you look at this slide, you can find the differences regarding requirements among jurisdictions. As I think Thomas already mentioned, UK recently issued the response to its consultation on intellectual property and artificial intelligence, and in which the government intends to amend copyright law to make it easier to analyze materials for the purpose of machine learning. The government's intends that anyone with lawful access to material protected by copyright should be able to carry out this analysis without further permission. And recently, Singapore introduced a broad TDM copyright exception last year, which can be applied to even the commercial TDM activities. but the TDM exception in Singapore only applies to the lawfully accessible works. And as far as I know, China is also currently considering the introduction of text and data mining copyright exception in the administrative regulations. So as Thomas introduced, mentioned already, and the Japanese TDM exception is quite broad. Therefore, I would say Japan-based AI developers are very much advantageous, thanks to the broad copyright exception. So while EU-based AI developers cannot fully benefit from copyright exception. So I usually say I can recommend you introduce broader copyright exception for text and data mining. In fact, as far as I know, not a few European scholars are in favor of a broader copyright exception for text and data mining. So, but of course, I guess that EU member states have to concern the flexibility in implementing the CDSM directive into national laws. That was my first comment. The second point, and what struck me most, is the relationship between TDM activities and fundamental concepts of copyright. Thomas stated in his recent article, with respect to foundational concepts of copyright, the law protects the original expression of ideas, not ideas themselves, nor mere facts or data. So accordingly, text and data mining should not be considered a copyright infringement, but a matter external to copyright's scope. Also, in the preceding working paper, it is stated addressing TDM as a copyright exception is conceptually wrong and theoretically flawed. Then today, Thomas asked a question in the last two slides. Is the intended function of copyright to offer data holder control over data-based downstream markets, such as AI development? So it's quite interesting observation. Now, I'd like to touch upon the theory behind the Japanese text and data mining exception. As I mentioned before, the Japanese text and data mining exception is quite broad. But why? What is the justification for that? So the Japanese TDM exception belongs to the so-called flexible copyright exception for non-enjoyment purposes, which was introduced in 2018, which is not the same as the US style fair use clause, but it is relatively flexible. So I cannot go into detail today, but the basic idea behind this provision is that copyright is a right protecting only an interest in the inherent exploitations, which are aimed at enjoying or causing someone to enjoy a work. an exploitation of a work is not aimed at enjoying, such as text and data mining. Text and data mining is not aimed at enjoying. Copyright doesn't need to cover such exploitation. So therefore, in my eyes, the Japanese text and data mining exception can be considered as the internal limit to copyright, the internal limit to the scope of copyright, rather than the external limit to copyright as a result of balancing with other fundamental rights or the public interest. So also in Europe, I'm sure you know, there are some theories which try to exclude TDM activities from the scope of copyright based on, for example, the theory of a use as a work. So in my understanding, such similar idea can be seen here, that TDM activities are beyond the inherent scope of copyright. Because TDM activities do not prejudice the copyright holders' interests that are to be protected by a copyright law. And similarly, if I understand correctly, also Thomas tried to exclude TDM activities from the scope of copyright on the ground that TDM activities are just aimed at using ideas, principles, facts, or data that are not protected by copyright. So I agree with the idea in this regard. So I hope I understood correctly. So that's what I'd like to make comments to the excellent presentation. Once again, I'd like to extend my congratulations to Thomas for great work. Thank you very much.
Thank you very much, Tatsuhiro, for your very thoughtful comments. Before we shall turn to our second commenter, Anna Andreevich, would you like, Thomas, to quickly react to the comments that have just been made to you by Tatsuhiro? Why not?
Yes, thank you, Jacques. Absolutely. First of all, thank you very much, Tatsuhiro. I don't have that picture, although I remember very well our time in Seoul. So please, if you have the chance, send it to me. It's very, very nice. I remember that event dearly. And I remember that already many years ago, we were discussing these issues, which leads me to a first point. Because as you have correctly pointed out, in Europe, you can hardly find an IP scholar supporting the current strictness of the TDM exception. One could wonder how much space for copyright theory is left in EU corporate law making. I think that is perhaps more of a less theoretical and more realistic or legal process connected reflection, but I think it's very relevant because, and this leads me to a second point, I think that one of the issues with the current EU framework is precisely, as you point out in your analysis, that there is a mismatch between the union level and the member state level. We know how these political bodies work, so there is also some, difficult to avoid kind of throw the hot potato in the other field. That's an element of that. The European Commission would like more pointers by member states. Member states want more leadership by the Commission, and we end up with what we have. But if you take the inception impact assessment that led to the formulation of the original Article 3, which remained largely unchanged, you can see how the Commission, in assessing their understanding of the field of text and data mining, addressed mainly two sectors: the press publishing industry, legitimate, it's an important group of firms in the EU, so I don't have, of course, a criticism on that, connected to the fact that they consulted these needs. They have consulted the needs of academic researchers, again, very important. I don't have a problem with that, of course. I think that is certainly what they should have done, and that's it. So from the perception of the Commission at that point, you can see that the two main groups that were consulted was commercial publishers, scientific mainly, and university researchers. Not, we can discuss why tech companies were, or to what extent they were included. And, sure, Google is bad, is evil, and especially it doesn't pay taxes in Europe, or very little. And that is also an argument in itself when you have to pass certain laws, right? The kind of, political support that you obtain in these cases. But I think more scientifically, there was a lack of understanding that the stickiness of property rights in data could have had very long-lasting implications on technology and other fields. And this is what is happening, but there was almost a refusal to consider that. Probably because, if you're a corporate lawyer, you're not fully equipped to develop this analysis. It goes beyond copyright. So I liked your conceptualization of the Japanese text and data mining as an internal limit to copyright. I like that. And it helps me because I've struggled for a while with this kind of tension. On the one hand, I think that the first thing that I wrote in this field was titled, it was a blog post, but it was titled more or less on the absurd necessity of a text and data mining exception. Because in a properly devised legal framework, we shouldn't need it. I agree with you. It's not, sorry, I forgot the exact word that you used for the Japanese exception. Is a use that doesn't, so it's enjoy, exactly. Thank you. Sometimes in the US literature, I think it's non-consumptive uses. I say it's external, but I think that, these are all elements that more or less identify a common boundary of copyright law that we want to design somewhere, but we don't know exactly where. And then there is the reality. There is, and I call it regulating by introducing frictions. So every time that you introduce a concept in law that is not fully clear, you introduce a cost. It's not true that an exception, it's free. Because if you, I don't know, if you're a filmmaker, you know that if you film something, you know that if you're a filmmaker, the first thing that a producer asks you to distribute their movie is an insurance for potential copyright infringements. And the more you rely on a copyright exceptions, the more that insurance costs, right? So this is more of a legal realist kind of analysis, but these have cost. Every time that we are unsure, we are privileging those parties that can pay better lawyers. And we have to keep this in mind because this is the kind of consequences on the legal system that are difficult for us as lawyers to grasp because they don't end up often in courts. So when we perform our analysis on, on case law, we don't see this. But we see this if we apply, for example, interviews with startups or with researchers or with people who live in this field and somehow are subjected by these rules. And we see that they kind of produce a different different impact that maybe is not even the correct from a legal analysis point of view. But a legal analysis point of view, it's good if you are a legal analyst or if you have the money to pay a legal analyst. So I think that that's why I say, well, but at the end of the day, we need an exception, because otherwise, if we remain unclear, then we are kind of, benefiting those who, could acquire a license anyway. And that I think is more or less the element that is also present in the US, where they have fair use, but there have been calls to introduce a specific text and data mining exception in addition, because of course, fair use works for TDM, but it depends if it always meets the four factors. I don't want to talk too much, but I have a question for you, Tatsuhiro.
Perhaps if I may, perhaps you can keep that question on hold if you don't mind, Thomas, so that we can also hear from Anna, and then we can open up the discussion, and so that Anna can also share her perspective. We'd assume from Switzerland, so we had Japan, we had of course Europe and the EU, and let's now hear a bit about the situation under Swiss law that was already alluded to and that was on the table that you kindly shared with us. That's Bueno. So to you, Anna Andreevich, for your own comments on Thomas' presentation, and then we can, of course, get back to your question, Thomas.
Thank you very much. So considering the time, I promised to be short and efficient to make sure that we go straight to the point and also to get the chance to discuss a bit more about all of these questions. Reading your article, Professor Margoni, I was wondering, the first question I had in mind, which I think is extremely important, and I have the impression goes into a lot of scholars' head, is really the scope of application of this text and data mining exception. Because as far as I understand, so TDM has to be separated from the use of data, the copies and the use of data used to train AI systems. This is, in my opinion, from what I understand, actually not exactly the same. It's something that you mentioned in your article, and I quote you, we identify several pitfalls, including an excessively broad definition of TDM makes the entire field of data-driven AI development dependent on one exception. So my question is here, is it in your understanding the same, or how far does it go? How far does this text and data mining exception go? This would be my first question, which I think is extremely important also to understand if we are in a case where they have created a text and data mining exception with the aim to also be applied in the case of use of data in the training of AI system. But nevertheless, even though I believe it's not the same, also considering the differences in terms of technicality between text and data mining and AI, because the changes in terms of data are different. You prepare the data differently when you want to prepare data for the training of AI systems, but also because text and data mining, its purpose is solely on the extraction, copies, and comparison of data in order to have a result, versus the training of an AI system with data that has been prepared as well and collected as well, but that will be used to try to develop an automated system. So in my perspective, it's a different thing, and I wanted just to have your perspective on that and to understand also, in the perspective of your article, I wasn't very sure what was your understanding of how you thought the TDM exception should be applied, actually. So that was a point that was very interesting to me. But nevertheless, I believe that between TDM and AI, there are some important comparisons to be made, the first of which is the collection of data. And as you mentioned in your article, and I think is interesting, is that with the risk of having bad data, we have the risk to develop second-class AI applications. I quote the article, which I think is very interesting also in terms of first, transparency, because we have, if we use bad data, we have a risk and we cannot see where the data comes from when we use the model. Also, because when you mention in your article, when we use an AI model and we transfer an AI model, we don't have to transfer the database. So here is the problem of transparency. If you transfer an AI model, but you don't see how the data was collected, whether or not all the authorizations have been asked, whether or not it was protected or not, etc., we have a problem here, not only in terms of transparency, but also in certain cases in terms of liability, which I think is extremely an important point to be made, both in terms of TDM and AI, because interestingly, when we look a little bit about the preparatory work, when it came to the creation of this TDM exception, not much has been said about the data collection. It was all about the licensing system because we wanted to tackle that, and that was the most important thing, but it wasn't much about whether or not we should be interested in the data as such. So again, I understand that here the point was to avoid all this licensing system, which was quite complicated for publishers, for actually researchers who were using the publisher's licenses to access the data. But I think it's interesting and something interesting to compare between AI and TDM in general. So coming to AI, I just wanted to, and data collection, I just want to illustrate my point here. So recently, maybe you've seen Getty Images, so it's more from an artistic perspective. We'll go back to the beneficiaries here, because once again, Article 3 is only focused on the beneficiaries, such as research institutions and what is the second one? Cultural heritage institutions, sorry. Versus all the others who are under Article 4. Well, here let's talk about all the others, and some of them are journalists, as you mentioned in your article, but also artists. And so Getty Image recently, and I just shared an article in the chat, has decided to prevent the use of its data, so images, to create new AI creations, AI works. So this is typically, I think, what we can see from not here publisher, which, as you mentioned, rightfully were the main focus of the TDM exception, but here a company that has decided to say we don't accept these other companies, so such as those behind DALL-E, Midjourney, etc., which are tools used to create new arts, to use our data, so our works. So here is typically, we can already see actually what companies can do and how they can prevent and decide that certain beneficiaries, at least here, cannot use their data. The problem is, as we can see, is that not only the companies that create those tools are prevented from using these images, but in the end, it's also the end user, the artist, who cannot access through these tools the data, and also directly the data. So even though they have focused mostly on these companies that are beyond DALL-E and Midjourney, I suspect that all AI creativity can also be prevented from being created on the basis of the data, which I think is an interesting new development here. New tools have also been created in terms of data collection, and I will finish it here, such as this one, which is called Have I Been Trained, which taps into different databases used to train different AI models. So basically, an AI artist can use this tool in order to detect whether or not his or her work has been used in AI models, which is interesting to train AI models. So here is an interesting, also very recent development I wanted to share with you. So with all the data collection perspective, we already have a problem in terms of, again, its protection, where it comes from. And interestingly, when you talk to AI researchers, which I had the opportunity to do not so long ago in Switzerland, you see that they're not that much interested in how the data was collected and whether or not it is protected, but they just solely refer to the license that is on the database. So they will not do the work to go as far as checking whether the data is protected or not, whether all the authorizations have been asked, etc. They will solely refer to the license. And that is also interesting because it has pushed a new development in biometry in AI, which is the creation of artificial data, basically. And this data is completely created by the AI Institute, which then will use this data and not other people's data, which can be a problem not only from a copyright perspective, but also data protection perspective. And they will just train the AI system on that. So far, they cannot completely train the AI system just on this artificial data. they have to have a mix of it because it's not performant enough if they just train on this artificial data. But it's an interesting development, and to try to, in this case, tackle the problem of data collection. The second issue I wanted to come, and I'll finish with that. So it's the comparison again with TDM and AI. It's the licensing system again. So here, as I was mentioning, all the licenses are really the reference, the point of references of researchers to see what they can do and what they cannot do. So going back to the TDM exception in Switzerland, what is interesting in comparison with the EU is that we don't have this opt-out mechanism. And one explanation is precisely to try to involve not only research institutes, but also all other beneficiaries. And they also had in mind cases where, and I think that's an important point, where you have research institutes that have spin-off companies, for instance. What do you do in this case? Because you can use text and data mining in one case, and then you cannot, can you use the results you have for text and data mining or the copies you have used for text and data mining then for the spin-off companies? Probably on the Swiss law, but not so sure on the EU law. So that's an interesting point, an interesting development that I wanted to share with you. And I think that's it. I wanted to try to be short, and I think I've reached my goal. But I just had one last question for you. You've just mentioned that TDM exception has a cost. So for AI, should we avoid having a specific exception for the use and copies of data especially for the copies of data in the training of AI system because it has a cost, in your opinion, or is it not necessary to create that? Lots of authors I've seen have said that because of the technological aspect of the training of AI and because this AI transforming data, so in numbers concretely, to be used, it's not necessarily a problem from a copyright perspective, and we should avoid altogether, and we mentioned that in the conversation, should avoid altogether even having such an exception. So I just wanted to discuss with you this point here. Thank you very much.
Thanks very much, Anna. Here again, a lot of wonderful comments on your presentation, Thomas. I guess you may want to react perhaps first to the point on the question that you had yourself to Tatsuhiro Ueno, if I remember correctly, and perhaps generally comments that have just been made by Anna and Tatsuhiro Ueno too. Before we can open the floor for discussion, and I would invite all the participants to join in, and perhaps also in the interest of time, perhaps share your reactions and potential questions also on the chat if you would like to proceed that way. Thomas.
Gladly, thank you very much. So I'll ask my question to Tatsuhiro, but thank you very much. And I hope I have been able to type down all your questions. If not, please send them to me. They are very interesting. My question for Tatsuhiro is honestly somehow connected to one of your points, so we can maybe cover both. Let's start with the last one. TDM has a cost. As any exception, the more, so if you remember that diagram that I showed, my main goal there was to convey the idea that every time you have to make an assessment, there is a cost, a transactive cost, a cost of legal certainty, etc., etc. So the more there are, the more general the concepts are, the more flexibility there is, the higher these costs are. Now, in a properly designed text and data mining exception, there should be one box, one decision. It is covered or not. But there are so many, and if maybe you don't remember, but there was quite a bit of red words, red text. All that red text were comments on the different ways in which that decision could have been interpreted. This leads to a situation where, I'll give you an example. Take the US. We always think that the US only has fair use. That's not true. It has at least 12 specific exceptions and limitations to copyright, except that no one uses them because they are so narrow, so many conditions that everyone resort, or almost everyone resorts onto fair use, right? This is like some sort of a reflection of this dynamic. It happens, and sometimes it happens intentionally, that you regulate by introducing friction, right? You don't forbid something, but you make it costly, more difficult, a bit more uncertain to obtain. And that sometimes, as said, is intentional, sometimes it's just the result of a compromise hardly fought between different interests during the legislative phase. However, the ultimate result is very similar. It's that in the EU, unless you are a research or cultural organization acting for research purposes, only limited to the right of reproduction, only if you have lawful use, you cannot be overridden by contract, but the relationship with TPMs is a bit more problematic, etc., etc. You can enjoy that exception. Otherwise, pay. But pay who? There is no market. CMOs, they declare that we cannot cover this, right? Even if they could, what is the individual value that you could attribute to one data sets when you have to mine millions, billions, right? It's simply that there is no market. Possibly the only very small market is the one of scientific publishers that operate as scientific databases right now, but that with regard to their own needs, and that database is already protected by APIs, technological measures, trade secrets, etc., etc. So to me, this legislation is really very, very poorly devised. And I like a broad exception, such as the Japanese one that Tatsuhiro pointed out. But here's my question for Tatsuhiro. Maybe my knowledge of the Japanese legal system, of course, is very limited. Did Japan recently pass a reform of the unfair competition law where they introduced some sort of cause of action for data with limited disclosure? So something that it's based on unfair competition is not a property right. But if this is more or less correct, I think it is because I found it on the official website of, I think it's WIPO or the Japanese government. How does this work with text and data mining? I mean, it's covered. What is the interact? Why did you do that? If you have such, a kind of technological oriented legislator that understands the needs of technological development. I was very curious about that, because this could be categorized as introducing a bit of friction, right? And making things less certain.
Tatsuhiro, would you like to react and offer an answer to that?
Yes. Thank you very much. I was surprised that Thomas knows well about the recent development of the Japanese law. As you correctly mentioned, the Japanese government introduced big data protection by amending the Unfair Competition Prevention Act, not by introducing a sui generis right for the big data protection. So in 2019 or 18, about which I have written an article, so I will send you my article. And so after the enactment of the amendment of the Japanese Unfair Competition Prevention Act, a certain kind of big data is protected by the law. The regime is similar to protection of trade secret. It's not a property right approach. And so I am very often asked, what is the outcome of the amendment? But my answer is no court case law and no, I don't know. I have no idea. So, but the point of your question is the friction between the text and data mining copyright exception and such kind of a new regime for protecting the big data under the Unfair Competition Prevention Act. It's a good question, but I have no idea so far. But I think the protection under the Japanese Unfair Competition Prevention Act protecting a certain kind of big data does not cover and it text and data mining activities basically because the new regime for protecting big data under the Unfair Competition Prevention Act just cover a very limited unlawful act such as unlawfully obtaining the big data from the annals. So so I think that the new regime would hinder the effect of the Japanese broad, very effective, valuable, helpful copyright exception for text and data mining. So I hope that answered your question. Thank you very much for your question.
Thank you very much. I don't know whether, Thomas, you wanted to react to that or have another comments to make.
Thank you very much to Tatsuhiro. I think it's very interesting. You clarified a bit because I was aware of that development, but I, of course, can only understand on my own to a certain level. I found it interesting because it's somehow a different approach than what the EU has purported to do in Article 35 of the proposed Data Act, where for a couple of years we were expecting an extension of the, I understand they are different, but an extension of the sui generis database right to machine-generated data, precisely to protect the investment in data generation, either with a property right such as the SGDR, or one of the options was through an unfair competition remedy. And then when the Data Act was published, I personally was surprised to see, positively, but surprised to see that the Data Act clarifies that at least in the case of IoT, Internet of Things generated data, the sui generis database right does not apply, or has never applied, because that's a clarification, not an amendment, in the words of the Commission. So that's, I think it's interesting, because it seems to me that there are two common themes where the European model in text and data mining got it a bit wrong the first time, and Japan got it better, having a broader exception, less friction, more legal certainty. And then they both pose some sort of remedy. So the European Union tried to remedy with the issue of property right in non-personal data by excluding them. And Japan maybe tried to come a bit back with introducing an unfair competition remedy, which for me is much less problematic because it's not a property approach. I think that here a central element, it's the theory of property rights. And the fact that if you recognize a property right, is not the only right that exists in the legal dimension. Property rights have very specific features and characteristics, and often they are problematic precisely for the unintended consequences. An unfair competition action, to me, it would have been perhaps even acceptable in the European framework, because reduces a lot of this kind of frictions. But you know, I hope we will have soon the chance to discuss this more, because I find it a very interesting development. Thank you.
Thanks very much. We're almost running out of time, but I just wanted to read. There's a question which has been put in the chat, which is whether there are any, and I quote, implications and linkages for EU competition law. And perhaps a question to you, Thomas, whether you have given some thoughts to that potential interaction with EU competition law in the discussion that we're having, knowing that there are many interactions which can be complex ones, so I doubt that we can address that issue fully, but that'd be great if you could just say a few words about that topic.
I'm not a competition lawyer, so you know that's a first big limitation of responsibility. But certainly, if you look at a lot of the new legislative interventions that I have mentioned as the governance-based approach, many of them have a competition law nature, and quite interestingly, an ex-ante competition law nature. So they enter in the field, broadly understood at least, they enter in the field of a regulation of fairness in contract in the case of B2B and B2C, and to some extent B2G. They determine that specifically the Data Act. We haven't mentioned them so directly, but the DSA and the DMA, so the Digital Service and Digital Market Acts, also attempt to regulate quite meaningfully very large players in this field by imposing extra conditions on their operations. And all of this is done with the declared scope to limit the power and influence of very large platforms in the European market. So certainly there is, you know, I think that the way in which I try to represent this governance-based approach is an approach that mixes different fields of law. So it's not as, you know, pure disciplinary speaking as the property-based one, mixes different fields of law. If you look at the Data Act and the DGA, you can see that different chapter talks about very different things, from regulating fairness in contract to establishing ownership, not ownership rights, but rights of accessing co-generated data, to the creation of intermediaries for data brokering, etc., etc. All this is fascinating. Is a lot. Is like new legislative interventions published in the last of articles, and perhaps even, well, not all of them hundreds of articles, but certainly not the usual, you know, 10 articles that we had in the directives of 20 years ago. And the recitals as well, if you take one of them, are 250 pages, including the impact assessment, right? So it's very difficult to follow single-handedly, but I think this is the direction, and competition law plays a role. I'm sorry if I cannot tell you much more. It's not my field, but I'm sure that an expert in this area could possibly agree and add even more in this sense.
Thank you very much. I think we are about to come to an end, also because even though Tatsuhiro Ueno is very brave and courageous, it's getting very late in Japan. So I think we should wrap up. And
can I answer a last question from Anna?
Sure,
many. Very briefly, because I think that that's probably her first one, and I think that has an impact on everything else. Text and data mining and AI are not the same thing. I agree. In the scientific field, they are two different things, but I'm afraid that in the way in which EU corporate law defines text and data mining as any automated analytical technique aimed at analyzing text and data in digital form in order to generate information which includes but is not limited to patterns, trends, and correlations. This is not text and data mining, but is the text and data mining definition of EU copyright law, and covers a lot, not everything, but a lot of the processes that we have to perform in the field of AI, especially that area of AI that is based on machine learning. And this is one of the criticisms that I try to make in my paper, unintentionally, because I'm pretty sure that the Commission didn't want to regulate AI through copyright. They have the AI Act, right? So unintentionally, they ended up with a broad definition inserted in a narrow exception, and they ended up de facto regulating AI. And that's a bad thing, just to be clear, but has happened.
Thank you very much. Yeah, I agree with you. So it's a interesting insight, and thank you very much for taking the time to answer my question.
Thanks. Thanks very much. I think there are many takeaways, and certainly a discussion that shall continue. Just like picking up on a few points that have been mentioned by our speaker and our two commentators. This aspect of regulatory competition that you mentioned, Thomas, is of course of highest interest and relevance. Also trying to see, and I was trying to think, and I have no answer, is it easy or kind of an unavoidable and unmanageable challenge to try to locate where the data processing takes place, with all the issue to which you alluded relating to the application of law, private international law aspect. Also the point that you just referred to, which is the call for interdisciplinarity, and meaning that many legal fields shall be applied. And I also like the reference that you made to the GDPRization of non-personal data. Is it really the way we should go in terms of also making the system workable and understandable? That's a question that remains, at least from my perspective. Of course, we learned a lot, as I already had a chance to hear on other occasions from you, Tatsuro Ueno, in terms of what you've done in Japan, but also the issue which certainly would need to be further explored from my perspective with respect to the mandatory or non-mandatory nature of the exceptions. My understanding is that there is some flexibility from that standpoint under Japanese law, which may, of course, have a significant impact on the way how that can work in practice, knowing that licensing may be widespread and might be also a tool somehow to minimize or reduce the impact of the exemptions, or even exclude them totally. And without further ado, because its time is now up. Anna, your point about artificial data, I was thinking that that might be connected to synthetic data. I guess the way how you can somehow recreate data which would avoid all the legal hurdles and be less risky or not risky at all to use in the future, if that's feasible. So quite interesting approach also that we may discuss at a future edition of our AITPT. So now time for me to wrap up and to thank very much our speaker, Thomas Margoni, and our commentators, Anna Andreevich and Professor Tatsuro Ueno, for a truly excellent session. Many thanks for your time. Special thanks to you, Tatsuro, for staying up so late with us. And I already invite you to join us for the next session that will take place on November 15th with a topic around AI and deepfakes. And last but certainly not least, also my dear deepest gratitude and thanks to Amir Joseph, who has organized the session. So many thanks to all of you. Wishing you a good evening for some of you, or a good rest of the day, and for Tatsuro in particular, a good night. So thanks very much, and see you again soon. Thank you.
Thank you indeed for having me today.
Thank you very much. Thank you, everyone.
Thank you very much.